Thanks, Peter. So the case I'm going to deal with is the South Durban Community Environmental Alliance versus the MEC for Economic Development, Tourism and Environmental Affairs in KZN. The content of this case certainly isn't directly relevant to the COVID-19 pandemic in the same manner as, for example, the NSPCA case that you dealt with, Peter, given COVID being a zoonotic disease. But I do think, and from a personal perspective, I found it a very interesting judgment because it raises several really important procedural issues. And just, again, for those who aren't practitioners, I'm going to try and make this not boring because it can get a bit dry. But from a practitioner's perspective, it's incredibly interesting because these are procedural pitfalls that the judgment addresses procedural pitfalls that I think we really need to be aware of when advising clients on whether to take matters on review. Because I think there's often, and I certainly experience in my practice, a misconception that if an administrative appeal is unsuccessful, then the next step is just to take it on judicial review without an appreciation for the really fine nuances of a review application and the hurdles that you actually need to jump over in order to achieve a favorable decision. And what the outcome of a favorable decision in a review actually is, given its procedural nature. So this case concerned the development of a logistics park in the South Durban Basin. The applicant was Capital Property Fund Limited. They'd applied for and obtained an environmental authorization, which was then challenged by the Alliance. The area has a history of environmental injustice and is already plagued by excessive atmospheric emissions. There are 2 refineries there and a paper and pulp manufacturer. And the Alliance was concerned that this new activity was going to cause a disproportionate amount of negative emissions. So the first issue which the court actually had to consider was which decision the Alliance ought to have challenged in the review application. And in this instance, the Alliance had only sought to challenge the appeal decision that was unsuccessful. It hadn't taken on review the department's initial decision to grant the environmental authorization. And the court looked at a number of different judgments that dealt with this point. Firstly, Wings Park PE versus the MEC for Environmental Affairs, where the court, Judge Plaskett, had actually said that if a decision in the first instance is unsuccessful, then, and an appeal decision subsequently is also unsuccessful, then an applicant on review needs to challenge both decisions. The Alliance had argued that although they hadn't actually challenged the department's initial decision in this instance, they said it wasn't fatal to their case because of the nature of the relief sought, which was not just the review and setting aside of the appellate decision, but an actual reconsideration of the case. The court also then looked at the judgment of Superside versus the Minister of Finance and upheld or agreed with this decision that it's not fatal to a review if you don't challenge both decisions. It very much depends on the decision of first instance and the nature of the relief sought. The difficulty in this case was that, and this is again something that I consider really relevant for practitioners taking matters on review, is that the Alliance had not distinguished its grounds of appeal and its grounds of review. It had in effect relied on essentially that none of the parties who had considered the matter had given due consideration to this issue around atmospheric emissions and disproportionate emissions in the basin. But they hadn't refined those arguments on review. They'd simply reiterated their grounds of appeal in the review application. And the court raised it alerted the Alliance to this and the importance of that distinction between an appeal and review. An appeal is a much broader inquiry, enabling a decision-making authority to really go into the merits of a matter, whereas a review is decided on very specific procedural points. And because of the issue of separation of powers and the court's respect for the discretion of administrative decision makers, a court is very hesitant to encroach on the turf of the merits of the matter and the executive's decision. Interestingly, the court, after having dealt with all of this, didn't actually decide the matter. It didn't decide on whether the Alliance's failure to challenge the initial decision had been fatal to its case or not. The parties had agreed that the matter would be heard anyway. But it's just an interesting point to consider. It's again, I mean, we've seen so many judgments, courts exercising caution when it comes to the distinction between appeal and review and their authority in that regard. The next issue that was interesting that the court raised was the issue around review on the basis of an error of fact. And it also ties into this distinction between appeal and review and the importance of courts not entering the fray on the merits. The Alliance had alleged that the MEC, as I say, had failed to consider certain important facts around air emissions and that the decision was consequently reviewable. The court looked at the judgment in PEPCOR and reiterated that where a functionary is entrusted with determining which facts are relevant and whether they exist, a court doesn't have discretion to intervene here. However, it upheld the judgment in Airports Company of South Africa versus Twelekgotso, which held that where a functionary exercises a competence to decide facts but gets the facts wrong, that is a basis upon which a court can intervene. But the facts in that instance have to be material, established, and objectively verifiable. And again, the court held that the Alliance simply hadn't established facts of that nature, and the Alliance was unsuccessful on that point as well. The third issue, which was very interesting in this judgment, was the issue relating to costs. And this is something that I certainly as a practitioner took a lot of caution from, because the court was actually quite scathing of the Alliance's conduct in the matter and used this as a basis for granting an adverse costs order to the Alliance, notwithstanding the fact that it's an environmental NGO litigating in the interest of the environment and the public. So ordinarily, in such cases, or certainly constitutional matters between a private party and the state, the principle established in BioWatch applies. And provided it's an issue of a constitutional issue, it's unlikely that if an applicant is unsuccessful, that it will be mulcted with a costs order, an adverse costs order. So in this case, although the MEC was a respondent, it had waived the issue as to costs, but the applicant, Capital Properties, had actually gone to quite a few lengths in implementing the decision, because as the court raised, one of the other issues with the Alliance's case is that they never sought an interdict. So they didn't actually try and stop the applicant from implementing the decision that it had been successful in. And the court took quite a dim view of this and said, well, if you wanted to take the matter on review, you ought to have also applied for an interdict. The issue with the BioWatch principle is that it's applicable between private parties and the state. So the court was also considering whether this principle could be extended. And one of the minority judgments, in fact, held that it could be by virtue of the provisions in Section 32 of NEMA, which also provide that a court won't award costs if the litigant acted reasonably and in the public interest or the interest of the environment. But as I say, the court looked quite scathingly at the conduct of the Alliance in this case. And one of the other issues that it raised was that the Alliance review application timeously, which is interesting because the applicant they'd launched the review application within 180 days. Now, ordinarily, PAJA prescribes 180 days from the decision within which one can actually launch a review. So, and I mean, often such proceedings are really launched at the 11th hour just in order to meet that 180-day deadline. But even in this instance, the Alliance's conduct in launching the application just within that timeline, even though it was in fact compliant with PAJA, the court still used this as a basis to grant an adverse costs order. So the majority judgment did not extend the BioWatch principle and held that the Alliance would in fact be liable for the applicant's costs. So I say applicant, I mean the project proponent. There were two dissenting judgments, however, on this issue, and both Nichols JA and Makhoka JA held that the BioWatch principle should be applied and extended in this context, given the kind of bridging provision that Section 32 provides, and that the Alliance should not have to bear the applicant's costs, that there should be no order in this regard. So again, it's a very interesting case from a procedural point of view, and I think I certainly took a lot of lessons away as a practitioner, constantly operating in the space of appeals and judicial reviews and seeking to advise clients who want to take matters further and feel very passionately about the merits of their case, cautioning them when it comes to review and how it's actually achieved and what the outcomes actually can be. That's my case.
Thank you very much, Kate.